選舉主席，大家提名。
Nominations, please. Mr. Tam Yu Chung. Dr. Priscilla Lang seconds. Mr. Tam Yu Chung accepts the nomination. Any other nominations, please? No, then Mr. Tam elected chairman.
Good
morning, and thank you. And please invite the administration to join us now. Please invite representatives from the government to come in. Good morning.
Okay.
Good morning. This is the first meeting of the Bills Committee on the Statute Law Miscellaneous Provisions Bill 2014. I've just been elected chairman. Now, this is the first meeting of the BC, but we have another Bills Committee on the Marriage Amendment Bill in progress, and the two Bills Committees have overlapping membership. So for this time we have no other alternative, but next time we'll try to avoid scheduling both at the same time. This bill is interesting in that it has got a dozen or so parts which are very different. So we may not have the same officials from the DFJ every time attending our meetings. So do we have any suggestions from the administration? Present today, let me read out the list. In fact, it's already tabled. I will spare the time. And administration, what suggestions do you have for us so that we can scrutinize the bill? Thank you, Chairman. As you have just pointed out, Chairman, there are 15 parts to the bill. The first part is on commencement date, and the other parts are actually independent of one another. Each part proposes to amend a certain ordinance, and the officers in charge are also different. This is the first meeting, and we have lined up a large team. If it is acceptable to members, may I suggest that we go through the bill part by part, including the commencement date, the policy, and clause-by-clause scrutiny of one part first. For instance, starting from Part 2, amendments relating to sexual offences. Once Part 2 is done, we go to Part 3, amendments to the 3 anti-discrimination ordinances. I believe if we proceed this way, it will be more systematic, and that will facilitate the record-taking by the Secretariat. And then we can also arrange for my colleagues to attend under the instruction of the committee. Perhaps towards the end of each meeting, depending on the progress of the Bills Committee, the chairman will tell us which part we're going to deal with at the next meeting, so that we can invite the relevant officials and relevant parties to be present. I'd like to hear members' views as well, because this is a rather special bill with 15 parts, each on separate pieces of legislation. So perhaps we deal with the bill part by part first. We go through the policies, and then clause by clause scrutiny. And after a certain part is done, we go to the next part. Is it acceptable to members? Yes? Yes, that's okay, Chairman. Because there are 15 parts, it's hard to ask overall questions or general questions. So for the first meeting, I don't know which part should we focus on. Can you tell us what parts we're on? I think they've already done so. Now I have got a paper in English. I have set out all 15 parts, the length, the content, and also the bureau responsible. Please refer to this chart and see whether you can divide the bill into sections to facilitate your scrutiny. And then we can be flexible depending on the progress. The discussion on certain parts may be longer than that for others. It's not easy for us to have a very firm idea about the progress, because we don't know members' concerns. If you want us to tell you exactly which clauses we are on in a particular meeting, it may be difficult. Sometimes we may be faster, sometimes we may be behind schedule, but we'll try our best. Today is rather exceptional because all policy bureaus are present, with the exception of the judiciary. If members have policy questions on any of the parts, that's okay. What we are discussing is the arrangements starting from the next meeting on. Now, if you have this chart with you, part 1 is on commencement date. It's also divided into 3 parts. Usually, the commencement is on the date of Gazetto, but there are 2 parts which are special. For instance, Part 9 is other proposals from the HAB I think we can discuss the policies and commencement date when we are at Part 9. So for Parts 2 and 3, they are longer, or the policies involved are more complicated, and we can deal with it today. Parts 4, 5, 6 can be another meeting, and 7, 8, 9 can be lined up for still another meeting, and 10 through 15, they all fall under the DOJ, and they can be taken together. So this is one way of how we should proceed. All right, we try our best. Mr. James Stowe. Now, this is just my guess. For Parts 2 and 3, because another meeting on KSW is ongoing, I suggest we skip Parts 2 and 3 today. I have to join the other meeting, actually, for fear of no quorum. I think we can take up the amendments to the technical amendments first. Even for briefing of the bill, I think the administration can brief us on other parts first. So it is hard for us to forecast the progress, but DOJ will always be present. Now, if in a particular meeting there is time left, then the DOJ can always take members through the more technical amendments. But if Mr. James Stowe would like us to skip Parts 2 and 3, today we can start with other parts. Yes, my suggestion is you start with other parts first, and for the next meeting first, we must not clash with the BC on marriage amendment or bill, and then we also tell members that for the particular meeting we're dealing with Parts 2 and 3. Yes, the Secretariat will let colleagues know, and those who are interested will make it to the relevant meetings, and we'll try to avoid the BC on marriage amendment bill as well. So why don't we start with Parts 4, 5, 6. Members, if you don't mind, I like to accommodate colleagues from other bills first, because Parts 4, 5, 6 are under the DFJ. So if members do not mind, can we start with 7? Amendments to Unsolicited Electronic Messages Ordinance. All right, Parts 7, 8, 9, 3 parts. All right, and Mr. Peter Charles Mock is also here. So should we go to the bill now? All right, the policy first, Part 7. Amendments to Electronic Messages Ordinance, Unsolicited Electronic Messages Ordinance. Page C1430, the blue bill. Yes? C1430 of the blue bill.
So this is Part 7, Amendment to Unsolicited Electronic Messages Ordinance relating to service of specified notice. Mr. Chang Chi-Kung, please. Mr. Chang.
Yes, thank you. Part 7 seeks to amend Section 44 of the UEMO for the purposes
of serving the notices issued by the Communications Authority pursuant to sections 34, 35, 36, and 38 of the ordinance. Further modes of service, namely delivery by hand and sending by ordinary post, may be adopted in addition to sending by registered post under the existing provision. So the objective is to enhance the effectiveness of the enforcement action taken by the office. Mr. Chang, can you tell us the content of sections 34, 35, 36, and 38? What offences are included in these sections? Is it that you've detected problems concerning the serving and delivery of notices, and as a result, this amendment is proposed? Now, under sections 34, 35, 36, and 38, notices can be given. Under section 34, instructions can be given concerning communication records. Section 35, fines. Section 36, requiring a person to provide information concerning investigation. And then Section 38, enforcement notice to be served. Anyone who does not comply with the notice commits an offense. So it is important that we can serve the notices effectively. Under section 34, the notice can be sent by registered post to the correspondence address or the last known address. But then some have not provided us with their addresses, and some refuse to receive the mail items, and as a result, we can't take enforcement action. In order to enhance the effectiveness of the enforcement mechanism, we propose to amend Section 44. So in other words, there can be other modes of service, namely delivery by hand and sending by ordinary post to the last known address. So as a result, enforcement action can be taken subsequently, and this amendment is necessary. Mr. Charles Mock. But that if you just leave the notice at the address, you don't know whether that person has actually received the notice or not. But then this is to facilitate your enforcement action, right? You can't locate him, you can't deliver the item to him by hand, and as a result, you just send it by ordinary post, and then you can take enforcement action. Now, in fact, there can be service at a certain address, but then very often at the address, nobody can be found because the service can be operated by remote control. So we will leave the notice at the address at a location so that when people come to inspect the equipment, they will see the notice. In fact, many of the servers are in the data centers. But is it that you can't obtain information about that person from the data center? Will you try to do that? Yes, you are right. We'll try to do that. In fact, we've tried. Previously, the notices were sent by registered post, but then people refused to receive the mail. They didn't go to the post office to collect the mail item. And so we are proposing that sending by ordinary post should also be accepted, so that there will be more flexibility on our part. Yes, there will be more flexibility, but then do we find this approach acceptable? Chairman, I wish to follow up further. We understand that email has become a very popular mode of delivering messages. I think it's ironical that this is an ordinance about unsolicited electronic messages, but then you've chosen to serve notices not by email but by registered post or ordinary post or delivery by hand. Is it because these notices are very important, as a result they can't be sent simply by email? Can a D of J tell us whether for very important notices they cannot be sent by email and they must be sent by registered post or preferably delivery by hand? Mr. Chair? Yes, I thank the member for his question. Now, in fact, we have an email system. We do have detailed records concerning emails sent and received. But then concerning unsolicited electronic messages, very often those who send these messages make use of third-party email to store the emails and to send the emails. In fact, we've received a lot of complaints. People say they have already sent out emails refusing to accept unsolicited electronic messages, but then the messages are still sent. After investigation, we discovered that yes, such refusals have been sent out, but then the emails are sent by a third party. And so sometimes automatically such messages are brushed aside, and as a result and sometimes an email may be resent to another email account. In fact, we've received a lot of complaints. We've handled many such cases. And it's important that the enforcement notice be duly served on the person concerned, because if one doesn't comply with the enforcement notice, one commits an offense and will be prosecuted. And that's why we prefer means like delivery by hand, sending by ordinary post, or leaving the enforcement notice at the last known address. But then concerning emails, as third-party email systems may be involved, we don't know whether the enforcement notices are really received. You mean they may make use of third-party emails like Yahoo and Gmail, and in fact, those who have complained to you, in fact, have said that they can't really contact the senders of the email by email. And so if you serve the enforcement notice by email, it's very likely that those concerned may not be able to, or they may claim that they have not received the mails. All right, Mr. Albert Ho, do you wish to ask a question? This is the Unsolicited Electronic Messages Ordinance. And I believe we're talking about electronic messages here. But it seems that Clause 51 is not about electronic messages. Thank you. This is about the CA serving notices on those concerned. So it seems that here we're not talking about electronic messages. Yes, I agree. So the ordinance is about the regulation of the sending of electronic messages. But then the CA needs to serve notices on those concerned. And at the moment, we were talking about sending by registered post. So here we're talking about serving of written notices, not electronic messages, correct? Yes. You talk about the last known address of abode or business, unless there is evidence to the contrary. What do you mean by evidence to the contrary? Now, if you send the notice to an address and then the notice is returned to you and nobody lives there or nobody has received the mail item, does that constitute evidence to the contrary? Yes. Is this just the usual practice or have there been previous cases? In fact, we've sought advice from our own lawyers. If we send a letter to a person and that letter is returned to us, then we cannot assume that that letter has been received. Can the D.J. supplement for returned mail items, are they regarded as evidence to the contrary? Ms. Wong. Concerning evidence to the contrary, it really depends on the circumstances of the case. The situation mentioned by the CA is one example. But what if a mail item is returned, says this person cannot be found at the said address? You see, sometimes you have this chop by the post office. It really depends on the circumstances. Was that person telling a lie, or was that that person had moved or the correspondence address had changed? So we have to look at the circumstances of the case, whether the sender has really sent the mail item to an address where the person can receive it. But what if the post office applies a stamps a chop there saying that there's no such person at the said address? As chairman, concerning in the absence of evidence to the contrary, now this appears in 1 capital A, and this is only about the time of serving the notice. So if the notice is left at the person's usual or last known place of abode or business when it is so left, or if the notice is sent by ordinary post or registered post on the second day after the day on which it is so sent. So in other words, this doesn't apply to 1, correct? And what if the post item is returned? Now, Mr. Chang may wish to supplement. When we received the request from the CA and the Bureau, we were told that they had difficulty serving the notice. In the ordinance, there was only one method of delivery, sending by registered post, and if someone receives knows that it's an item from the OFCA, then he knows that it's an enforcement notice, and so he will not receive the letter, or he will say no such person, and then he will return the letter to the sender, and as a result, the OFCA cannot take enforcement action. And that is why the CA has proposed that further modes of service be adopted. In fact, in other ordinances, delivery by hand and sending by ordinary post are also accepted as modes of service. But then we noted Mr. Ho's concern. You can't, right at the outset, send the enforcement notice by ordinary post because there is a possibility that that person may not be able to receive it. The OFCA, in many cases, has exhausted ways to deliver the notice, but then the person concerned has refused to receive, and as a result, the OFCA is of the view that either it has to leave the notice at the person's usual or last known place of abode or a business, or it has to send the notice by ordinary post. OFCA in fact, has had experience of trying to send the enforcement notice, but the other party refuses to accept or receive that mail item.
Mr. Badu, well, I understand the administration was thinking about enforcement difficulties. However, the downside of such an amendment is, well, some officers will just go for the easiest way out and just send by post to the last known address or business address. So that person never receives that post, and he is deemed to have done so, and there will be a lot of legal liability. So you really rely on the administration's undertaking that this provision would not be invoked lightly. What guarantee do you have for us to ensure that there will be no abuse? Because this will have wide implications on the industry. That is whether the law enforcers will invoke this provision in a fair manner. That is to ensure that they will not just go for this in the first instance. Yes. Now for Clause 41A, evidence to the contrary, well, this is already in the original provision, and it is by means of registered post, and we have now added an extra route, that is by ordinary post to the last known address. It is true that some receivers do not carry out. Now we need to submit evidence to ensure that the other things have been done, and we have to submit evidence to the court. But according to here, it is said that the person, the notice presumed to have been served once it is sent by ordinary post, because I'm worried that an officer may not first use 1A, will not use other means and go to 1A at once, and the person may be held liable as a result. I'm just a bit uneasy about this. So it's easier for the law enforcement. But how can you ensure that there will be no disputes? I'd like to know whether a similar provision is found in other ordinances. When we drafted this clause, we also made references to recently passed legislation by LegCo on the service of notice. Now, there is always that presumption of a notice having been served, but still this is just a presumption. If there is evidence to the contrary, if the addressee can submit evidence to the contrary, then he can say that he has never received such a notice or information or message. It's quite commonly found. Mr. Ho, I think that will only apply to 1A. So 1A is about the point of receipt. 1, in subclause 1, there is no mention of in the absence of evidence to the contrary. Can you add this to 1? Okay, can you think about it? Yes, we can think about this. But we have to consider the policy intent of the TA. Yes, I will ensure that members concerned can be allayed, and will also make reference to similar provisions to ensure that this is the most commonly accepted way of drafting. If members feel fit, perhaps the administration can give us a list of examples in other legislation. And this is also about implementation. The original requirement is just by post, but now there are two additional options: delivery by hand and also by ordinary post. Perhaps colleagues from the TA can confirm the following. If it is sent by ordinary post, and if the addressee can submit evidence that he has indeed moved without notifying the TA, if he can submit evidence that he is no longer conducting business there, would the person be prosecuted or not? So this is one of drafting as well as the actual operation of the provision. All right, sections 34, 35, 36, and 38, what are the consequences of such notices? If the consequence is serious, then we must ensure that the person really gets the notice. It's just like an injunction. It has criminal liability, and therefore you have to ensure that the person receives it. So I would like to know the consequence of not complying with the notice under these sections. All right. There are three provisions involving the serving of notices. Section 34 to give instructions to service providers to require information. What if the information is not provided as demanded? The TA can issue an instruction to ask him to do so, and if he doesn't do it, then he breaches the licensing conditions. That means he'll be prosecuted, maybe fined. So it is for enforcement of the licensing conditions. If he fails to comply, there may be civil or criminal liability. Okay. What about Section 35? To impose a fine on telecommunications service provider. So it is criminal. What about 36? To require the relevant person to provide information. It's usually the investigation of a case, and we require information to be provided. So it's something serious. What about Section 38? If we cannot serve the notice, we cannot prosecute the licensee for a breach of licensing conditions. So it's something serious, of course. Otherwise, there is no need to amend the ordinance. Mr. Mock, I agree that some of the issues are serious, but I asked whether we have similar arrangements in other pieces of legislation, and our legal advisor has just requested the administration to give us examples at the next meeting. And to follow up on Mr. Albert Ho's question, I'd like the TA to give us information on the following. Mr. Albert Ho is concerned about the possible consequence. The consequence can be serious. It can be a fine or a breach of licensing condition. In an extreme case, the licensee may lose its license as a result. However, from what I've observed, you really could not locate the persons. So can you share with us how serious the situation is? You talked about third-party providers and not being able to find the real licensee or the person in charge. Some of them are not really licensees, because when you receive a fax or an email, you will trace the server. The server is not the licensee, it is just sending out electronic messages. So sometimes won't even be able to locate the relevant person. I'd like to know how common it has been for you to not being able to contact or find out the providers. And what about prosecution figures under this ordinance? This ordinance has been in operation for many years, since 2008. I'd like to know how many prosecutions do you have? I think you only had the first case recently, so there have been no prosecutions other than that. Thank you. For sections 35 and 35, telecommunication service providers usually it operates well. Usually, the service providers, well, they have a very proper electronic communications system. They will not reject or avoid our correspondences. But for 36 to seek information from relevant persons, according to experience, is also very smooth, because if they breach, Section 36 will require the will invite the magistrate to serve a notice. And for 38, we have issued 23 notices, and 15 of them could not be delivered for certain reasons. So it's just 35% success rate. That is far too low. To improve our enforcement system, we propose to add these two options. Earlier this year, we had the first prosecution, and it is still in progress. For the 23 enforcement notice, can you tell us whether they were about fax or faxed messages, electronic messages, or what? Do you have details? I don't have the details, but most of them were faxed messages, pre-recorded telephone messages, and SMS. Okay. 38. Well, I already talked about Section 38 enforcement notices. Okay, you've got 20 or so. I seek this information trying to address Mr. Albert Ho's question. Well, 23, I think this is limited because many members of the public have received unsolicited messages. So if out of 23 you failed to deliver 13 or so, the cases. So you see many people are trying to use stalling tactics. Mr. Albert Ho. But if some of the notices have serious consequences, then for the sake of natural justice, you have to ensure due diligence in sending out notices. We should not just consider it from the point of administrative convenience. In very serious case, you can advertise on the post. So if it is really serious, or rather, you take advertisements on newspaper to let a certain licensee understand that he cannot be located, and he is being served a notice through the advertisement. I'm not proposing that now, but I have to consider how serious the consequences can be. Can the TA supplement? Now, even if we have enforcement notices issued under Section 38, there may not immediately be criminal or liability. I think still prosecution is needed. If the prosecution, when submitting evidence, shows that The notice is just by ordinary post, and the notice hasn't been sent through registered post or hasn't been delivered by hand, and if there is no evidence to prove that the TA has exercised due diligence, then I believe the court may not necessarily regard the notice has been served.
I don't think the courts will accept such weak evidence from the prosecution. I say the person may be able to prove that he has already moved, he is operating at another business address. So how come the OFCA simply delivered the notice by ordinary post, and then when the notice was returned to the OFCA, it could assume that the in fact the notice already been adequately served. But then if it is presumed that if it is presumed that he has already received a notice, then the judge may have no alternatives but to impose a penalty, although it can be a lighter penalty. I understand that for civil proceedings, if the notice has been sent to a particular address, then the person will be deemed to have duly received the notice. But then here, I think it's not the same as a civil case. There is a presumption, unless you add in the absence of evidence to the contrary. Right, so perhaps you can consider the suggestion after the meeting. Legal advisor, I just want to say this to Mr. Ho and the administration. Now, in fact, concerning Section 38 of the UEMO is about serving enforcement notices on those concerned, and the offense is in Section 39. It says that if someone fails to comply with the enforcement notice, if someone fails to take the necessary action, then prosecution action can be taken under Section 39. So if there is prosecution, and if the defendant says in court that he hasn't received the enforcement notice, then on the surface, I think that can constitute a defense. But then that would mean that, but that will happen only when there is prosecution, and as a result, the defendant has to satisfy the court that he hasn't received the enforcement notice. So in this scenario, there may not be a need to include the words in absence of evidence to the contrary. So perhaps the administration can consider whether these words can be included. All right, so let the administration consider the suggestion. Mr. Chang said that 23 letters were issued, and in 15 of the cases, those concerned said they had not received the letters. So the success rate, so to speak, was only 30%. So one can't help suspecting that people have deliberately refused to refuse to receive the letters, and these are of course letters from OFCA, and they are sent out properly, but these people are saying that they haven't received the enforcement notices, and so the OFCA wants more flexibility for its enforcement work, but of course we can decide whether we accept it. I think we have to be fair when we talk about public policies. We shouldn't do things for the sake of convenience or flexibility. Now, I think if people deliberately refuse to receive the enforcement notices, of course we need to tackle this problem. But then I think fairness overrides convenience. Some have really moved out, they've moved elsewhere, and they can't really receive the enforcement notices. So the paramount concern must not be administrative convenience. But apart from administrative convenience, they're also talking about failure to take enforcement action effectively. So we shouldn't use the word convenient or convenience. We should look at feasibility. So if a certain section of the law is not enforceable, then we will need to, of course, solve the problem. When I use a word meaning convenient or convenience, I may give rise to misunderstanding. In fact, what I mean is we need to make the law enforceable. All right? Right, can you go back and consider this matter again? All right, thank you. Perhaps we can also look at the clause itself. And we have the marked up copy, page 0041. English version, and Chinese version 0060. And in fact, this is provided by the legal advisor, right? 0041 of the English version. English version 0041. The marked up copy.
政府邊位代表同我哋講講？
So who can take us through the amendment? Oscar?
楊生，
係好啊嚇咁
Mr. Chang from the OFCA, please. Yes. A specified notice may be served on a person where the person is an individual by delivering it to the person by hand or by leaving it or sending it by ordinary post or registered post to the person at the person's usual or last known place of abode or business. The notice is presumed to have been served in the absence of evidence to the contrary if the notice is left at the person's usual or last known place of abode or address, or business rather, when it is so left, or if the notice is sent by ordinary post or registered post on the second day after the day on which it is so sent. Legal advisor, please? Nothing? Right, any questions? I hope that they can add subject to evidence to the contrary under 1. There is no need to give me a reply today. I think they can consider it after the meeting. All right? All right, let's move on to the next one. May I suggest that we now deal with Part 8, Chairman. Ms. Chen from the CEDB. C1432. C1432. Amendments to Trade Descriptions Ordinance relating to standard of proof for defense. Yes, thank you. Thank you, Chairman. Yes, perhaps I can take members through the proposed amendment to the Trade Descriptions Ordinance. In 2012, there was a ruling by the Court of Final Appeal concerning Section 26 bracket 4 of the TDO. And it's about legal proceedings. If the defendant can prove that he did not know, had no reason to suspect, and could not with reasonable diligence have ascertained that the goods are goods to which a false trade description or false trademark is applied, then that's a defense. And what is the ruling of the CFA? It says that Section 26(4) of the TDO must be read down as imposing merely an evidential burden on the accused, with the persuasive burden remaining throughout on the prosecution. This is because under Section 26 bracket 4, it says if the person charged could not with reasonable diligence have ascertained that the goods are goods to which a false trade description or false trademark is applied. Now, according to this defense, the prosecution has to, beyond all doubt, prove that the person, in fact, knows that the goods are goods to which a false trade description or false trademark is applied. In other words, the accused really needs to show that an evidential burden. The persuasive burden remains throughout on the prosecution. In fact, there are other provisions similar to Section 26(4). So we have also Section 12 and other sections, and that's why the amendment is that if there is sufficient evidence, and then if the prosecution cannot provide evidence to the contrary, then the charged person may be acquitted. Yes, as Ms. Chan has pointed out, now the proposed amendment arises from a CFA case. The CFA has ruled that Section 26(4) of the TDO must be read down as imposing merely an evidential burden on the accused, and the persuasive burden remains throughout on the prosecution. Chairman, with regard to Part 8, we've written to the administration, and in fact that letter has been tabled. With regard to the CFA's ruling under Section 26 bracket 4, we want to know whether the administration will be looking at other defense provisions in other ordinances. And such defense provisions may have to be reviewed as well, because they are very similar to Section 26 bracket 4. That would mean a much wider scope. Mr. Albert Ho, sorry, I didn't really quite understand, although I read law. I believe I'll have to read the judgment before I can fully understand the implications. Does it mean that with the amendment, the accused is going to have a lesser burden of proof or evidence? Let's not use very complicated or technical terms. Is it that the CFA thinks that it's unfair to require the person charged to provide the persuasive evidence? Now, in fact, under the principle of presumption of innocence, the CFA is of the view that Section 26(4) in fact is putting the persuasive burden on the accused, and that will be against the principle of presumption of innocence. And so the CFA rules, or has ruled, that the accused only needs to prove that he did not know, had no reason to suspect, and could not with reasonable diligence have ascertained that the goods are goods to which a false trade description or false trademark is applied. So the person charged only needs to produce some evidence, and according to the CFA, the accused only has an evidential burden. He doesn't need to prove to the absolute extent that he did not know, had no reason to suspect, and could not with reasonable diligence have ascertained, blah, blah, blah. In other words, the person charged only needs to provide evidence, and the prosecution has to prove beyond reasonable doubt these three criteria. For example, the prosecution needs to prove that in fact the charged person did know, had reason to suspect, or could with reasonable diligence have ascertained that the goods are goods to which a false trade description or false trademark is applied. And so the CFA is trying to clarify that there is only an evidential burden on the part of the accused.
Okay.
I think we're talking about the ABCs of criminal law. That is, the suspect or the accused only has to raise reasonable doubt, and then that will be efficient. That will be sufficient. Sufficient evidence means reasonable doubt. So the accused is not required to submit persuasive proof. Is that right? So has the Court of Final Appeal declared the original section unconstitutional? Has it been deleted? It has been written down. But that means it is unconstitutional or invalid. So we believe it is better to make it clear that the provisions impose only an evidential burden on the accused. But it is more than 26(4). And similar amendments are made to the ordinance. So for the accused in that case, was he acquitted or had he to go through another trial, a retrial? But we don't have the case law here. Oh, there is no need to do so. Once the court has declared it, to declare that the provisions should be construed in this way. Now, the court has already ruled that Section 26 is unconstitutional, has been read down. Then even if the Policy Bureau doesn't make an amendment here, the provision is no longer valid. So the burden of proof is rather light. The accused need only to raise a reasonable doubt. All right, then I understand. But as our legal advisor said, we need to carry out this exercise and check other relevant pieces of legislation. Is the current drafting problematic? So, Mr. Wen, it is something for you to do. Well, different policy bureaus are responsible for different ordinances. This time, the CBD told us that it is going to amend the trade description ordinance because of that case. Now, if we to do it to all the legislation in Hong Kong as a mammoth exercise, but it should be done by the Solicitor General of the DFJ. I think this mistake appears in all ordinances, so I think they need only to go through a computer check. But of course, the outcome is just the same. The court has already read down this ordinance, but for the sake of consistency, I think such an exercise should be done. I don't think it is as simple as that, because the context may be different. This time we'll talk about trade descriptions. In another piece of legislation, it is a different matter. And the accused will have to prove or to submit different evidential burden. So it should not be for the Bureau or for the DFJ to decide. We must work with the Bureau to see whether there is any difficulties when it comes to the operation. When the burden is on the accused, it is usually because it is very difficult for the prosecution to prove. For instance, whether the person knows this can only be proved by the accused himself, and therefore legally it is acceptable to put the burden of proof on the accused. So we have to consider each and every pieces of legislation and to find the right balance. Here, the Court of Final Appeal accepted that the evidential burden should be on the accused. This is because even they have tried, because it is easier for the accused to tell whether he has exercised due diligence to tell whether the trade description or whether a forged trademark has been applied. So it may not always be unconstitutional if we put the burden of proof on the accused. Yes, I know. In 1992, we had the first case involving the drug ordinance, but the final burden of proof must be on the prosecution. The prosecution has to prove beyond reasonable doubt, and the accused can only submit only has evidential burden, and sometimes there is the question of proportionality. But the proportionality also depends on the context. The extent of difficulty should be taken into account before we can say whether it is proportional. So at this stage, it is difficult to carry out a full review. DFJ, with such a ruling by the CFA, will you inform different policy bureaus that there's been such a case? Usually, when our prosecution division has got such a ruling from the court, it will certainly inform the relevant policy bureau. No, I'm talking about different policy bureaus. For instance, will you tell different policy bureaus that, well, this has happened? Yes. Depending on the bureau in charge, it will be informed of the situation. And therefore, in this case, the CEDB has decided to amend the legislation. No, I'm talking about other policy bureaus. Of course, the bureau concerned will know. But what about other policy bureaus? We also let them know that there's been such a ruling and ask them to be mindful of similar scenarios and to propose amendments where necessary. Now, if we note that the ruling is related to other policy bureaus, we'll certainly inform them. For instance, in a similar miscellaneous provision amendment bill, we found out the provisions in different pieces of legislation that involve the a ruling of the CFA. We also informed policy bureaus to see whether there is room to amend the relevant legislation. Okay. If members have no questions, let's go to the marked up copy. 0061. Chinese and 0042 English version. Please see whether there is anything about the drafting. Legal advisor, please. The marked up copy, please. Yes. We have written to the administration on some technical and drafting points. Please refer to page 61. Amending clause 12 or Section 12 and 2A is now added. Perhaps I will briefly explain to you how this will operate because it looks complicated. Now, 2A sets out some conditions. If these conditions are satisfied, then the accused would be acquitted. So, bracket 1A, a small a, is about what the accused has to do. As pointed out by the administration, according to CFA's ruling, there is only evidential burden on the accused. So, the accused needs only to adduce sufficient evidence to raise an issue. There is no need for him to prove anything. And we have got big capital letters A, B, and C under this. The accused has to prove all three before he can satisfy the condition under Roman letter 1. So this is the first step. This is what the accused has to do as a first step. And then Roman letter 2, that is the responsibility of the prosecution. Now, if the contrary is not proved by the prosecution beyond reasonable doubt, as pointed out by Mr. Albert Ho, the burden of proof has always been on the prosecution. If the accused has adduced sufficient evidence which the prosecution can prove to the contrary, then the accused will still be convicted. However, in Roman 2, it says here that if the prosecution cannot prove beyond reasonable doubt, and if Roman 2 is satisfied, then the accused will be acquitted. So I've tried to explain in simpler terms what this amendment is about. And what is our concern here? Now, assuming that there is an accused who can adduce evidence, as pointed out in Roman 1. For instance, he can prove that he did not know, and B, he had no reason to suspect, and he could not with reasonable diligence have ascertained. Now, if the accused can adduce such evidence, and the problem lies with Roman 2. Prove to the contrary. That means the prosecution has to prove to the contrary beyond reasonable doubt all 3 points, capital A, B, or C, or just one of them. Now, if after the court has heard all the evidence and is satisfied that if the accused have exercised reasonable diligence, he should have ascertained. Now, this is an objective test. If the court is of that view and yet doesn't know whether the accused did know or had no reason to suspect, although the court is of the view that the accused could have ascertained with reasonable diligence. All right, Roman 2 requires the prosecution to prove to the contrary beyond reasonable doubt. I'd like to know whether the prosecution has to prove all 3 or just one of them. Well, in our drafting, we have made reference to the ruling by CFA. Now, the accused has to prove A, B, and C, and we have consulted the relevant colleagues in DOJ. Usually, the prosecution, in their ordinary course of work, needs only to prove just one of the 3 points, either A, B, or C, for the accused to be convicted, legal advisor. That being the policy intent of the government, I suggest that in Roman 2 of small letter A of 2 capital A, I think you should make it clearer, because the current drafting may create an anonymity or ambiguity. The reader won't understand whether it should be all three, A, B, or C, or just one of them. So please consider making it clearer.
Yes. In fact, we've studied this matter with the legal advisor, and we will take a look at this again, because this new section will set a precedent, and we have to ensure consistency in the future. And so maybe at the next meeting or at a future meeting, we will report back to members our decision. All right. It should be or. It's not reasonable to expect all A, B, C to be proved. Right? Please look at this again. All right. Do members have any further comments on the drafting aspect? No? Then let's move on. Part 9. Yes. Building Management Ordinance. From the Home Affairs Department. Oh, sorry. Still some more. A legal advisor. Are there other points to note? In fact, we have also amendments to Section 26, so there are a few more pages. All right, let's look at 0026 Chinese version. Ms. Chan, thank you. So we've just discussed the amendments to Section 12, and now we're on Section 26. To delete the existing Section 26(1), because this is affected by the CFA's ruling, and you can please now refer to the marked up copy, and the wording is the same, or is similar, or the format is similar to that in Section 12, and that is the person charged needs to adduce evidence to raise an issue that the commission of the offense was due to a mistake, reliance on information supplied to the person charged by another person, the act of or the fault of another person, an accident, or some other cause beyond the control of the person charged, and the person charged took all reasonable precautions and exercised all due diligence to avoid the commission of the offense by the person charged or any person under the control of the person charged, and the contrary is not proved by the prosecution beyond reasonable doubt. And then Section 26 bracket 2 is a technical amendment. And this is these are textual amendments in the light of amendments to 26 bracket 1. And then we have Section 26 3, Section 26 4. So we have the new 26AA and 26AAB. And they replace the original Section 26 bracket 3 and 26 bracket 4. And for the new Section 12A, in fact, it's consistent. In other words, the person charged has to adduce evidence to raise an issue that the person charged did not know, had no reason to suspect, and could not with reasonable diligence have ascertained that the goods or service did not conform to the trade description, or that the trade description had been applied to the goods or service, and that the contrary is not proved by the prosecution beyond reasonable doubt. Legal advisor, any comments? No. Mr. Albert Ho, here the word or the conjunction or is used. How come in the first part the word and is used? Miss Kwok? In fact, we're just trying to present the original provision in a revised format or manner. And so we just follow the original wording. Now, at the time, there must be some legislative intentions to either use the word and or the word or. So this time, we'll be looking at which word can best tally with the legislative intent, because at that time, the provision was modeled on a UK provision, so it's not as simple as just looking at whether it should be and or. Yes, Chairman, as the DOJ has pointed out, in fact, we follow the original wording, but then we have to make it clear that the accused only has an evidential burden and the persuasive burden remains on the prosecution. And concerning the three defenses, in other words, the person charged did not know, had no reason to suspect, and could not with reasonable diligence have ascertained, blah, blah, blah. And concerning the new Section 12(2)(a) and the new 26AA, 26AAB, the conjunction and is used. But then in the new Section 26(1), the factors in raising an issue are different. They are a mistake, reliance on information supplied to the person charged by another person, the act or default of another person, an accident, blah, blah, blah. And that's why, and here the word or is used. So we will sit down with the DOJ to see whether we should consistently use and or whether we should just follow the wording in the original version. I want to talk about 26(1), 26(1). 1A and then Roman 2.
All reasonable precautions and exercise all due diligence to avoid the commission of offence 咁樣。呢度嗰個舉證嘅即係嗰個提證嗰個。
And I want to know whether the standard of proof is the balance of probabilities, because under A, we're talking about raising an issue only. So is it that there is a heavier burden of proof under Roman 2? Who can give an answer, Ms. Kwok? According to our understanding and the drafting instructions, the evidential burden is the same. In other words, has to provide evidence that he has taken all reasonable precautions, blah, blah, blah. I'm talking about the standard of proof. The standard of proof. For A, the person accused has to raise an issue only. So in other words, there can be reasonable doubt. But then B, 2, took all reasonable precautions. So are we talking about balance of probabilities? This is different from raising an issue. But then if you look at the wording, under bracket A, we have sufficient evidence is adduced to raise an issue that, and then we come to Roman 1 and Roman 2. So raising an issue only. But then the evidence or the content of the evidence or proof should be the person charged took all reasonable precautions and exercised all due diligence. So the standard of proof is the same. Yes, it should be so. Legal advisor, can you please confirm? In fact, under small letter A, Roman 1 and 2, A1 and A2, are about the person charged having to provide sufficient evidence to raise an issue. Is that clear, Mr. Albert Ho? Yes. All right, we've looked at both the English and the Chinese versions. I think we can now move on to Part 9. Part 9. AA and AAB. Ms. Chan. 26AA replaces the original section 26 bracket 3 because 26 bracket 3 is about the person charged that did not know, had no reason to suspect, and could not with reasonable diligence have ascertained, blah blah blah. So because of the CFA's ruling, the structure of this provision follows a new 12A 2 and also 26 1. So this is 26AA replacing the original section 26 bracket 3. All right. Any questions? Legal advisor? Right. 26AAB, Chairman. 26AB, like 26AA, replaces section 26 bracket 4. This is one of the subsections ruled to be problematic by the CFA. So here it says that the person charged can adduce sufficient evidence to raise an issue that he did not know, had no reason to suspect, and could not with reasonable diligence have ascertained, and that's the content. All right, legal advisor, okay? So that's all for Part 8. So we'll now move on to Part 9. Amendments to Building Management Ordinance Cap 344. All right, Ms. Leung from the Home Affairs Department. Yes, thank you. Yes, perhaps I can take members through Part 9 of the bill. Under the existing provisions of the BMO, a member of the Management Committee of an Owners Incorporation is required to lodge a statutory declaration stating that he or she does not fall within any of the categories of ineligible persons specified in paragraph 4.1 of the Schedule 2 to the BMO within 21 days after his or her appointment, and a statutory declaration has to be made before a Justice of Peace, Notary Public, Commissioner, or other persons authorized by law to administer an oath. Many management committee members are of the view that it's very inconvenient for them to go to the designated venues during office hours to make statutory declarations. And so we are proposing to amend the BMO to replace the existing requirements of statutory declaration with the requirement of written statements. But of course, the written statement must be in a specified form and must be witnessed by an authorized person. And the 21-day limit will remain the same. Now say there is a new term of officers or members of the management committee. They have to go to work in the daytime, so they find it inconvenient to have to go to a district office during office hours to make a statutory declaration. And now I understand that there is a form. OC members sign on the form, and then the form hands over the form to the registry. But there must be a witness. Yes, anyone can be a witness. Yes, correct. And so the form is signed, and the witness has to sign, and then the form is forwarded to the Lands Registry. So why is it that at that time all the members had to make statutory declarations? In fact, that was in 2007 when the BMO was passed. Because management committee members played a very important role in an OI, and so that was why the members must not be bankrupt persons, and they must not have been convicted of offences attracting an imprisonment term of more than 3 months in the past years.
To ensure that he is not in the categories of ineligible persons, back then it was felt that he should be required to make an affidavit, however, or statutory declaration, and now people think that it is too stringent and it's also inconvenient. So we now believe that a written statement can achieve what we desire. So the person has to write a written statement, and he will be held responsible, and there's no need to ask a JP. Yes, if he has provided false information in the statement, then under Section 36 of the BMO, it is an offence punishable with a fine of $3,000 and imprisonment of 3 months. Okay. Perhaps Ms. Lam can explain to us that for Part 9 there is a special arrangement for the commencement date. It won't come into effect on the date of Gazzetto. Please refer to 1364, page C 1364. Because the written or the statutory declaration has to be submitted 30 days after the appointment, and then it has to be submitted to the Lands Tribunal within 38 days. So we suggest that the new clause would only come into effect 1 month after the enactment of the ordinance, so that the Lands Tribunal can be prepared, and will also make use of that time to publicize the new arrangements to all owners and corporation of the territory. So just to facilitate enforcement. Mr. Mock. Usually, I'd like to ask whether the department would check the information, whether the department will verify the information before and after the amendment. So the person makes that declaration or statement. That's true. I'd like to ask whether there was ever false information declared. Well, we have not seen any contravention since the taking effect of the ordinance, because it's clearly explained to the relevant persons beforehand, and it's unlikely that an eligible person would be a member of the management committee of NOC. It's just that with the amendment, the legal liability is clearer. So this is relatively simple. What about the drafting aspect? Page 0065 to 0067, the Chinese version. Any point to note here? Legal advisor, I have no further questions. Perhaps the administration can explain to us that on page 0067 there is a new clause 8. Yes. new clause 8. Now, if a member of the management committee has submitted his declaration and there are changes in the declaration, then he has to make a new declaration within 21 days. Because we are now replacing a statutory declaration with a written statement, we have to add this clause. Should there be any change in the details or particulars of previously submitted statutory declaration, the person can rectify it using a written statement. Is there any difference in terms of liability between submitting a statutory declaration and a written statement? When it comes to a statutory declaration, we have provisions to govern the procedures and other things, so it is very different from a written statement. So the requirements are different. Is it that a written statement is much simpler in law? Now, for a statutory declaration, we have another ordinance, and that is the oaths and declaration, and with fines, penalties. Okay. Any question? No. Then Mr. Leung. Ms. Leung, anything more? All right. Any problem with the English text? Any question, please? If not, we have completed parts 7, 8, and 9 this morning. I think it is about time we stop. Or do we want to continue? Or you want to wait until we have bigger, we have more members present? Then the Secretariat will discuss with the administration on arrangements for our future meetings. I hope that we can have 3 more meetings. Chairman, this morning, this meeting clashes with the matrimonial amendment bill. I hope we can avoid clashing the 2 meetings in future because there is overlapping membership. Yes, I understand that because the Secretariat didn't take this into account when scheduling the first meeting. In future, I will try not to clash the 2 meetings because there is overlapping membership between the 2. Thank you. I've also noted this. All right. That being the case, we will end at this point. We sometimes invite deputations to express their views. However, this bill is rather technical in nature and also contains miscellaneous provisions. So can we deal without public hearing? Well, we've already done parts 7, 8, and 9. In fact, we've got only parts 2, 3, 4, where colleagues other than those from DFJ need to be present. Can we focus on parts 2 and 3 next time? Because I heard earlier that more members might be interested in parts 2 and 3. All right. Okay, then we deal with parts 2, 3, and perhaps 4 at the next meeting. Okay. Chairman. In our notice of meetings, can we let members know what parts are involved? Because they may have special concerns. Otherwise, if they only know at the meeting, it's not so good. Okay, we will ask the Secretariat to tell members exactly what parts we are on at the next meeting. Okay, thank you. No other questions? Thank you. Meeting adjourned.